From the Pep Radio Newsroom, here are the stories we are covering today. More than 30 prominent Republican officials and conservative leaders filed an amicus brief with the U.S. Supreme Court on Tuesday, opposing a Tennessee law that bars transition-related care for minors. While the government has a role in keeping kids safe, that role is limited, and it does not justify the state second-guessing the judgments of parents acting in good faith who are best positioned to know what their children need, the signatories wrote. States have no business overruling the decisions of fit parents who make an informed medical choice for their children that is supported by their doctors, by the medical profession more generally, by the children themselves, and by their conscience. The Supreme Court agreed in June to hear the case, as Republican lawmakers in dozens of states have introduced bills to restrict gender-affirming care, including puberty blockers, hormone therapy, and surgeries for minors and, in some states, adults on Medicaid. So far, 26 states, including Tennessee, have adopted such measures. Pennridge School District School Board unanimously passed a first-read vote reducing parts of a controversial book policy supported by the previous Republican-led board. The original 5-page policy focused on sexualized content that opponents warned could lead to widespread book bans on LGBTQ-related content. It's been trimmed down to about 180 words in a newly revised set of administrative procedures for adding or removing resource materials from school and classroom libraries. Among the changes between the current policy and its potential replacement is a focus on sexualized content. A review of the current administrative procedures posted on the district's website shows the terms sex and sexual content appear more than 30 times. Curriculum appears just 5 times, and educational goals and educational standards appear only 3 times. Another controversial policy passed by the previous board could be up for reconsideration soon as well. An advocacy policy, better known as Policy 321, is part of the school board's policy update plan, a recurring agenda item. That policy's stated goal is curtailing classroom discussions on myriad topics, including sexual orientation and gender identity, unless those discussions relate directly to a lesson plan. Approved last September with the current resource materials policy, Policy 321 riled up residents and teachers who felt the broad rules would curtail free speech. Supporters, meanwhile, said it would prevent political activism in schools. It's unclear when the review of the advocacy policy will take place, but word said Thursday that it could appear on a policy committee agenda as early as next month. The current version of Policy 321 is among a handful of guidelines developed in quiet coordination with Harrisburg-based independence law firm. Policies drafted by this firm have appeared in dozens of school districts across the state over at least the past year. The group has more recently been hired to review policies pro bono in several districts in York and Beaver counties, and more recently in Crawford County. WESA in Pittsburgh is reporting that homeowners and renters facing housing discrimination in Pennsylvania now have more clarity on how monetary damages are calculated for emotional distress. The state's Human Relations Commission, which is responsible for enforcing state laws prohibiting discrimination, approved new guidelines last week. Caroline Esther is the commission's director for fair housing and commercial property. She said the new guidelines will further protect those facing housing discrimination. It establishes a framework for determining monetary damages related to emotional distress resulting from humiliation and embarrassment caused by discrimination, particularly in housing. She said the guidelines are intended to be flexible since every case is unique. The complainant can receive between $5,000 and $35,000, even if their testimony is not supported by a witness or medical evidence. The monetary range increases to $50,000 to $100,000, with witness testimony and medical evidence pointing to mental health damage. Damages greater than $100,000 that would be appropriate for egregious discrimination, where the acts would be ongoing over a significant period of time. Eister said most housing discrimination cases in Pennsylvania involve people with disabilities. She said some common examples of housing discrimination include refusing to rent to someone because of their sex, race, or religious beliefs, failure to make reasonable disability accommodations, and charging a fee for a support animal. That's a check of today's LGBTQ plus news. For Pep Radio News, I'm David Moore. Now let's get back to the music.